This morning, CNN cameras captured the glimpse of one of those individuals, Carlos de Oliveira, the man federal prosecutors say schemed with Mr. Trump and Walt Nauta to shield evidence from federal investigators. The Mar-a-Lago property manager made his first appearance inside a federal court, and we're going to start there in South Florida, where CNN's Randy Kay is posted. So what did we see this morning, Randy?
Well, Dana, this was our first look at Carlos de Oliveira as he entered into the courthouse here just behind me. He was wearing a navy blue suit and a tie. He went inside with his lawyer, John Irving, who was here from Washington, D.C. When he stood at the lectern to address the judge, he said good morning, and then the judge proceeded to lay out the charges that he is facing. He said he understood the charges. He said he understood that he had a right to remain silent and speak to a lawyer. Then they went on to talk about a bond. The judge went on to set a $100,000, what they call a personal signature bond, so he doesn't have to pay it, but he doesn't have to stay behind bars right now. He was also asked, Dan, about a passport. He says that he said he does have a U.S. passport, but it's expired. Still, the judge told him that he had to turn that over within 48 hours. He was also told he can't leave South Florida without permission, the area of South Florida. And then he was also given a witness list of the list of government witnesses, and he was informed that he cannot speak to any of those witnesses that are on that have been identified as witnesses for the government. I can tell you he did not enter a plea. That will take place on August 10th. There is going to be an actual arraignment on August 10th in Fort Pierce, Florida. He did not have a Florida barred attorney, which means he couldn't enter a plea. He needs somebody who can practice law in the state of Florida to do that. So that will happen on August 10th. And of course, Dana, all eyes are watching this because, as we know, his case is now pushed back. His arraignment is pushed back, which could impact Donald Trump's case when it comes to the Mar-a-Lago documents. And that we, of course, want to see whether or not he would go to trial before Election Day. That's certainly something a lot of people are watching, Dana.
Randy, thank you so much. Not having an attorney present, delaying things,
Sure.
That sounds pretty familiar at this point in terms of tactics.
For more on the legal implications of all these developments, let's bring in former state and federal prosecutor David Weinstein. Thank you so much for being here. I want to go back to the classified documents case. We know that Carlos de Oliveira has just left court. They could not do a full arraignment because he doesn't have a Florida attorney yet, but he's been told not to speak with some of the other witnesses that are in the case, which did not at this point include Donald Trump and Walt Nauta, who are both defendants. Does that seem odd to you?
Not at all, Sarah. In all of these cases, it's very difficult for the government to prevent you from speaking to one of your co-defendants. It's essential, especially if you have a joint defense, either agreement or theory of defense, for a defendant to be able, at least through his lawyers, to speak to his co-defendants. Not unusual that they don't want any of them talking to witnesses who have been listed or revealed, but not so unusual that that doesn't include the other co-defendants.
You just mentioned something that I think a lot of people are looking at, where Donald Trump's organization, or Donald Trump, is paying for the attorneys so far for Walt Nauta and Carlos de Oliveira. Is there a real danger in here for those two defendants that they won't get proper counsel?
I think there is, and I'm surprised at this juncture. Certainly, I know that they inquired of Walt Nauta at an earlier hearing, and once Mr. de Oliveira gets permanent counsel, they'll inquire of him as well, and that's the court, whether or not he understands that if a lawyer is provided for him, that lawyer's loyalty should be to him and not to the people who are providing the lawyer to him. And that's an important thing for the judge to get into, and I wouldn't be surprised if the government didn't press it a little bit more, especially with Mr. de Oliveira.
We heard that employee number 4, who is Mr. Taveras, is not facing charges, but it is potentially what he said about Carlos de Oliveira that turned that into an indictment. Does that give you an indication that Taveras is perhaps cooperating with the prosecution?
Oh, it certainly seems that way to me, Sarah. I think that they sent him a target letter, or at least that's been what's reported. They sat down with him. He gave them what they believe is truthful testimony. And they've either given him immunity for the statements he's providing to them, or at some point down the road, they're going to ask him to plead guilty to some charges. But based on what's contained in the indictment, it would appear that he is, although listed by them initially as a target, perhaps moving his way towards a witness for them in this matter.
So conversely, could that mean that Carlos de Oliveira was contacted and did not cooperate because he is now facing numerous charges?
Well, that seems that way to me as well. I think if they were going to give a target letter to the other witness, they've certainly given a target letter to de Oliveira. And what happens is you get the letter, you engage counsel or not, you have conversations with the government, and here he did because there were some statements they believe he made were false, and then you're given a choice. You can either come on board and cooperate with the government and accept an offer that's on the table, and if you don't, at some point they're going to say, well, we're going to indict you, and that's what happened last week. They reached that point where no offer was accepted, and then he got indicted.
I have a question for you as a former prosecutor. You know, we see Donald Trump defending himself on his social media account. Do you think that's a good idea? Some of the things that you have seen him put out there, angry tweets about, or Truth Socials, excuse me, about all sorts of things, including those who are trying this case?
Not at all. He's his own worst enemy. I mean, quite frankly, the best thing that any client of mine should do is to be quiet, not make any public statements. If they want to say something, say it to me, and then I'll talk to you about it. But he's really shot himself in the foot here, and you can see that in the superseding indictment. They added another count related to the document that was shown at Bedminster that he had said there were no documents, there were no papers. He's publicizing his defense. He's attacking the prosecution. I'm surprised that at some point a judge doesn't issue a gag order to keep him quiet. We've seen that in other cases. And if you're not quiet, you stand the real possibility of being held in contempt.
Yeah, what has worked for him politically, clearly the polling shows, may not work for him so well legally, is what you're saying. David Weinstein, thank you so much for your analysis. Appreciate it.